We shall now proceed onto business and immigration law updates. This will be projected here by the Khurana Law Firm, where the Chief Attorney and Counselor at Immigration Law is none other than Attorney Ramesh Khurana. Attorney Khurana is kind enough to spend his precious time with us out of his busy practice to educate you and I of the recent updates in the immigration arena. Today, our moderator, Attorney Kenneth Haber, has a bucket full of questions for Attorney Khurana. Let's join this discussion and see what they have to say.
Hello, my name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General of the United States Department of Health and Human Services. With me today, we have Ramesh Khurana. Hello, Ramesh.
Hello, thank you.
Ramesh is a world-renowned, literally world-renowned immigration attorney. He has clients all over the country, from all over the world. And this is the Capital Forum.
Thank you for a very nice introduction, Ken.
My pleasure, Ramesh.
Thank you. Appreciate it.
Are you ready to talk about the H-1B visas today?
Oh, that is my first love.
Your first love. Well,
This is my first love. When we talk about immigration, H-1B is very dear to my heart.
Can you give, because I know we've talked about H-1B a number of times, but in
Yes.
case there's some new viewers today, can you give a thumbnail of what the H-1B is?
Oh, sure. Like you said, thumbnail, definition of H-1B, a little bit description. This is meant for professionals who have to perform a complex set of job duties, and for which the industry trend or the industry-wide practice is to hire people who have a minimum of bachelor's degree. So these are the kinds of parameters you look at it whenever a person approaches you and he says whether I am eligible to apply for H-1B, and if you see that what is the job zone requirement, keeping in view the nature of the industry for which the person is approaching us, then we will say whether H-1B would be applicable in this case or not.
Very good, very good. What are the rules concerning the H-1B beyond the normal 6-year period? Could you please explain the rules?
Sure, Ken. Again, this question is of great significance to many of the persons who are probably sitting in the audience. The reason is that there is a long queue for the purpose of green card, and unfortunately H-1B visa can be maximum for a period of 6 years unless there are some special conditions which are satisfied. Otherwise, that person on the expiry of 6 years has to leave for his home country. So there is no way that we can retain that person beyond 6 years. Now, what are those exceptions or special conditions? Like I said, there is a green card process, and for professionals who are on H-1B, the employment-based green card process is started by filing a labor certification request with the US Department of Labor. And sometimes it goes through and labor certification is completed successfully, and sometimes there is an audit. And when it is in the audit queue, it takes a year. So labor certification is not done immediately, especially those people who are applying during the 6th year. Now, the condition for grant of additional period beyond 6 years is that your labor certification request should have been pending at least for 365 calendar days. If you can show that, then you can file for extension of H-1B petition for 1 year. Or if it was chosen for an audit, it has been pending in the audit, and from the data processing to the audit date, it has been 1 year. And second condition is, even though it's not 365 days, but labor certification is done, let's say in 6 months, and you file the immigrant petition, which is called I-140, only premium processing basis, and the approval comes immediately in about 15 calendar days or so. So, in that situation, if I-140 is approved by USCIS, you can file for extension of H-1B status in increments of 3 years instead of 1 year. And there is third more condition when you can go beyond 6 years. Let us say that you physically stayed outside the United States during the term of your 6 years of H-1B, and if you stayed for 45 days aggregate time, so you can apply for lost period on H-1B, that is physical absence from the United States, and your petition will be approved for those particular number of days. So these are the 3 ways.
Wow. And you can recapture this time?
Yes, you can recapture this time. Let us say that your 6 years expire on September 30th, and you stayed physically outside the United States for 60 days. So you can file your H-1B petition to recapture the last period of 60 days, and you will be given H-1B for 60 days.
With the high-tech world we live in, so many people work via the internet, they telecommute. Can they do that and develop time, go back to their home country, work from the home country digitally, and recapture the time that they're out of the country?
You know, it's a very good question. Now, H-1B is only for the period when a person is working in the United States. And in some situations, when the H-1 period has lapsed, person has to go back to some third country, could be home country or some other country. In that kind of situation, it depends upon the employer, whether the employer is willing to allow the employee to work from his home, from abroad. It can happen, it's happening. I have seen in my practice where 6 years have lapsed, employees have been allowed to go back to their countries, and they are working from their countries, and they are waiting for the labor certification to be completed. And once the labor certification is complete and I-140 is approved, they can come back.
Amazing.
It's happening.
Yes, well,
It's happening.
this is the new world that we're talking
Yes.
about, the globalization.
Globalization and digital world, sure.
What about the spouses? How does this whole process affect the spouses of the visa holder?
You know, if there has been recently a change in regard to the spouses' work visas. Now, those spouses who are on H-4 visas, I am sure you are referring to those spouses who are otherwise unable to work. And if I-140 or the immigrant petition is approved, now they have been allowed to file for H-4 work authorization as from May 26th of 2015. So, based on the approved petition H-1B and H-4 petition, we have to give an evidence that I-140 is already approved, and H-4 work authorization will be given up to the period of validity of H-4 visa.
Very good.
It's very interesting. You know, I think it was estimated that during the first few months, a large number of such applications would be filed, because USCIS estimated that about 183,000 applicants would become eligible to apply for H-4 work authorization.
How does this interface with, children and their education that come over with the adult visa holder?
Now, when we say children, if children are under the age of 21, because that meets the definition of a child, and if child is over 21, that person is not included in the definition of a child. So, children under 21, they are also given H-4 visas, but children are not allowed to work on H-4 visas, but they can very well go to schools and colleges for the purpose of completing their education.
If their school has a work training program, are they permitted to participate in those?
As regards making any kind of income, no, because they are not allowed to work. This is only for the purpose of having a good status in the country. They can live in this country, and they can take any kind of education in schools or colleges.
They could take an intern program if it's non-paid intern program.
sure,
Get the
definitely.
experience and
Yes.
develop the background
Yes,
that'll
yes.
set them up for
Yes.
future employment.
Yeah, and remember, they are not issued any social security numbers. It's for children.
Yes.
So naturally, this is a kind of disability for them to work. They cannot work.
Right, right, but they can get the experience.
Oh, sure, definitely. Yeah. If the curriculum of the school or college permits it, sure.
Are there any quirks about the H-1B visa that that the viewing audience ought to be aware of, that could be a landmine for them?
You know, main thing is major landmine which we see in our practice is that if you are working for an employer, because these people, most of the times, I'm talking about IT people, they are working on some specific projects. And these projects are for very short durations. Sometimes it's for 3 months, sometimes 6 months, sometimes 9 months. Now, in I would say before July of 2015, now this was the practice with some of the employers. They were taking a liberal view, like if the person is moving to a different work location, they will just file the new labor condition application, which we call the LCA, and based on the new labor condition application, they would start working. Now, there was a decision by the Administrative Appeals Office in the year 2015. They said if there is a material change in the petition, like there is a material change in the work location outside the metropolitan statistical area, in that kind of situation, you have to file an amended H-1B petition. So, H-1B beneficiaries and H-1B employers have to be fully aware about this decision which was given by the Administrative Appeals Office. They need an amended H-1B petition. And the other fear with them is if they lose the employment, they lose the job, they go out of status. They virtually do not have time to find another job. So, they have to go back, and even if some period is left out of 6 years, or depending upon labor condition application, whatever it is, then they have to go back to their country, and they should be coming back as a result of consular processing. When I say consular processing, it's a new term. That means the employer will file the new H-1B petition and would say, let's say that person is in New Delhi. So, US Embassy in New Delhi, that will basically adjudicate the application for issuance of H-1B visa. Only then that person can come here.
If the LC has to be amended, does that mean it has to start all over again, or does it just have to be redone as far as the new location?
You know, when so H-1B petition is in 2 parts. One is the LCA, labor condition application. That means that is the foundation for filing H-1B petition. So, if the work location has changed, you file a new LCA, and there is a material change outside the metropolitan statistical area, then you have to file an amended H-1B petition. New LCA for the new work location will be included with that.
Does that require a whole new reprocessing of that
Yes,
LCA?
yes, yes.
So it can delay matters.
In fact, as regards LCA for the H-1B is concerned, it takes about 7 business days to accomplish it. Yeah.
So it doesn't take long.
Yeah.
I see. Well, that's really interesting. I'm sure that many people who are in this country, on the H-1B visa would really need to know this type of information.
I agree with you, Ken. Definitely. Yearly quota is about 65,000 and 20,000 for those people who have done master degree from USA. Out of 85,000, I would say 40 to 50,000 persons are coming every year from India, and they form part of the audience. and they love to hear about H-1B visas.
Yeah, I would imagine.
Yeah,
I would imagine.
they love to hear.
Well, I thank you very much for coming on in, and we'll see you soon.
Thank you very much, Ken. Appreciate inviting me here.
My
and I
pleasure.
enjoyed every moment my being present here.
Thank you.
Thank you.